Imagine finding out that a loved one's will, the document that's supposed to carry out their final wishes, may not be real. Maybe someone changed the document. Maybe a signature doesn't look right. Maybe you suspect someone created a fake will to benefit themselves. What happens next? A lot of people assume that forging a will is simply a family dispute or a disagreement over inheritance, but that's not how the law generally views it. A forged will can have serious legal consequences because it may involve both probate issues and potential criminal consequences. But before we talk about penalties, there's something important you need to understand about how courts look at suspected will fraud. There are actually two separate issues happening at the same time. One issue involves what happens to the estate. The other issue is about what happens to the person who allegedly created or used a fraudulent document. These are connected, but they're not the same thing. Understanding the difference is important because many people focus only on who gets the inheritance and they overlook the bigger legal consequences. Before discussing penalties for will forgery, it helps to understand what will forgery actually means. In simple terms, forging involves creating, changing, or even using a document in a way that's intended to deceive others. When it comes to wills, examples might include creating a completely fake will and pretending that it was created by someone else, or altering parts of a legitimate will without authorization. Forgery could also be falsifying a signature, presenting a document as valid when someone knows it's not authentic, or other things. But it's important to understand something. A will dispute is not automatically a forgery case. Sometimes families disagree about a will because they believe something was unfair, or they believe someone influenced the person who created the will. Sometimes there are questions about whether the person who made the will understood what they were signing. Those situations may involve legal concerns, but they're not necessarily forgery. Forgery requires something more, a deliberate act of deception. Because accusations like this are serious, the courts generally look for specific evidence, not just suspicion. A common mistake people can make is assuming that a suspicious-looking will automatically means that someone committed a crime. A document can raise questions without automatically proving forgery. Courts look at the evidence surrounding how the will was created, how it was signed, how it was witnessed and presented to help them understand if a will is forged or not. Another mistake that people make is assuming that proving a will is invalid automatically means that someone's guilty of forgery, but those are two different legal questions. A will may be invalid for many different reasons that don't involve criminal behavior. For example, a will might fail because it wasn't properly signed or because the person making the will lacked the ability to create a valid will at that time. But that doesn't necessarily mean someone committed a crime. Some people also might mistakenly accuse another family member of fraud before they understand the facts. But allegations of forgery are serious and can affect families, reputations, and legal proceedings. These situations require careful review. The consequences of forging a will may extend beyond simply losing an inheritance. So, what penalties can someone face if they forge a will? The answer depends on several factors, including where the case takes place and exactly what actions occurred. In general, forging a will can lead to serious consequences. The exact penalties depend on the laws of the state involved and the specific facts of the situation, but potential consequences may include criminal charges, financial penalties, civil consequences, and potentially even other legal action. The important thing to understand is that there's no single universal penalty for every case. The outcome depends on factors like what was done, whether the person knowingly acted dishonestly, the amount or type of property that was involved, and the laws where the matter is handled. Only an attorney who understands the specific circumstances can provide legal advice about what may apply in a particular situation. Every case is different. This video is for educational purposes only. It's not legal advice, but if you'd like to understand how the law may apply in your situation, if you're dealing with an issue like this, you can mention this video to the attorneys at Woodbury and Ibarra and they'll give you a free consultation. The website and phone number is in the description. These attorneys have a lot of experience in these specific type of issues and specialize in them. They can help you know what steps to take next.